Good afternoon, dear students. In today's class, we are going to talk about acceptance, and then we will talk about consideration. What are the legal rules with regard to acceptance, and what is consideration, and the rules regarding a valid consideration. Now, in your last class, we have talked about what is a contract. We said a contract is an agreement enforceable by law. And then we have also seen what are the essential elements of a valid contract. There were 10 essential elements of valid contracts, and we have discussed those 10 elements of a valid contract. And then we came to offer. We have seen what is the meaning of an offer and what are the legal rules regarding a valid offer. Today, we will understand what is acceptance. Acceptance is when a person to whom the offer is made signifies his willingness. That willingness is known as acceptance. When a person to whom the offer is made signifies his willingness, that willingness is said to be acceptance. Now, here there are certain rules that are to be understood in relation to a valid acceptance. Now, it is said that acceptance is like a matchstick to a train of gunpowder. Once acceptance is received, then the contract becomes binding. Then the contract becomes enforceable in the court of law. How should this acceptance be for it to be valid? That is what we will discuss now. First point is that acceptance must be given only by the person to whom the offer is made. Suppose A has made an offer to B. It is B only who can accept. C or D cannot step in and accept the offer. Okay, when an offer is made to a specific person, that person only has to respond to that offer by accepting that offer. Now here we have said offer is maybe a specific offer or a general offer. When a general offer is made, any person by doing what is mentioned in the offer has made his acceptance. But when it is a specific offer, the person to whom it is made only will have to accept the offer. Now in this, there is a case law, Boulton versus Jones. The name of the case is Boulton versus Jones. Now in this case, there was a business, and this business was sold by the owner to a third party. A business of hose pipes was there, and the owner of the business had sold off this hose pipe business to a third party, unaware that this business is sold. A previous customer placed an order for 30 hose pipes to the business establishment. Now, because the ownership was transferred, the new owner, he took the offer and delivered the hose pipes to the person who made the order. Subsequently, the person who made the offer refused to pay for these hose pipes. The case went to the court of law. In the court of law, it was decided that the offer was made to the original owner. It was not made to the new owner. So therefore, the offer, the acceptance by the new owner is not a valid acceptance because it was not made to this person in the first place. So here you see the offer must be accepted only by the person to whom it is made. Then the second point is the acceptance must be absolute and unqualified. Suppose I say that I want to sell my pen for rupees 50 to, he is not there today. So today I will sell the pen to say Nazia for rupees 50. Now Nazia has accepted the offer but has paid only 49 rupees to me, thinking that I will give a discount of one rupee for the pen. Now here what has happened? I made an offer to sell my pen for 50 rupees to Nazia. What did Nazia do? She did not accept it in full. It was not unconditional acceptance. It was accepted at only 49 rupees. And because it was accepted at 49 rupees, I can say that this acceptance is not valid because it is a qualified acceptance. It was not unqualified because there was a change in the terms of contract. So here, because it is not qualified, it is not unqualified, the acceptance is not a valid acceptance. Okay. Then the third point is acceptance must be expressed in some usual or reasonable manner. And if, for example, the person making the offer has told that it has to be accepted before a particular date and time mentioned, then before that date and time mentioned, the acceptance must be given. Okay. If the acceptance is given by beyond that date, it is not valid. If the acceptance was sought in a specific manner, suppose, for example, I made an offer to sell my pen to Nazia, and I told Nazia that she has to accept by calling and telling me, that she accepts the offer. That was my condition. But what did Nazia do? Nazia has given me a WhatsApp message saying that she accepted. Is this valid? It is not valid because I had laid down the term of acceptance as by calling and telling me. But what did Nazia do? She has given a WhatsApp accepting the offer. So because there is a variation in the way in which the offer is accepted, that acceptance is not valid. And it has to be reasonable and usual. Suppose I give an offer to sell my pen, and in the middle of the night, Nazia calls me and tells me that she will accept the offer. Is this valid? Because it is not the usual time for business communications. It is not the usual time for mercantile transactions. Therefore, this cannot be a valid acceptance because it is not in the usual time, in the usual manner, as is the custom, as is customary in the business. Okay. The next is offer must be communicated to the person to whom it is person by whom it is made. Suppose, for example, I have made an offer. You have to communicate your acceptance to me. You just cannot keep it in your mind that, okay, I will accept and then keep quiet. You have to tell me that you have accepted. You have to communicate to me that you have accepted. And how is this communication to be made? As I told you, in the usual manner or in a manner that is prescribed while making the offer. And then acceptance must succeed the offer. Okay. Even before I made an offer, you cannot say that you have accepted it. Okay, even before I made an offer, you cannot say that you have accepted it. So the offer must be first, acceptance must come next. Acceptance cannot precede the offer. Of acceptance has to come only after the offer is made. That is another rule. And if an acceptance, if an offer is rejected, suppose I have made an offer to sell my pen for ₹50 to Nazia. Nazia has rejected the offer. That is, acceptance is denied. Okay. Suppose that acceptance is denied. Subsequently, Nazia cannot say tomorrow, okay, I will purchase for 50. Once the acceptance is rejected, acceptance is denied, the offer stands cancelled. Subsequently, you cannot accept something which has been rejected before. So if Nazia really wants to buy the pen, she has to now make an offer to me. Sir, I am offering to buy your pen for ₹50. That offer is made by Nazia. Then I have to accept. Okay. So first I had made an offer which was rejected. A rejected offer, when it is subsequently accepted, cannot be a valid acceptance. Okay. So these are the legal rules regarding a valid acceptance. Then we will talk about consideration. Consideration is used in the context of quid pro quo. Quid pro quo, which means something in return. Something in return. Consideration means something in return. So where a person has entered into a contract, the contract should be for the mutual benefit of both the persons. Okay. When the contract is not for the mutual benefit of the person and it is only for the benefit of one of the parties, but not the benefit of the other party, then such a contract cannot be a valid contract. Okay. That contract cannot be a valid contract. So now we will see what are the legal rules regarding a valid acceptance. Valid consideration. We will call this as, just give me a second. Okay. Are you all with me? Somebody say yes or no.
Yes, sir. Yes, sir. Yes, sir.
Okay. Thank you, Gayatri. So there are 4 essential elements of a valid consideration. Okay. First, I will define what is consideration. When I'm defining consideration, please listen carefully. When at the desire of the promisor, the promisee or any other person has done or abstained from doing, does or abstains from doing, promises to do or abstain from doing something, such act or abstinence is known as consideration for the promise. When at the desire of the promisor, the promisee or any other person, okay, the promisee or any other person has done something, does something, will do something, that something is called as consideration. Now, if you look at the definition here itself, are the essentials. First is when at the desire of the promisor. So I should, on my desire, seek something, and you should, out of your will, give me that something. That something is called as consideration. That is the first essential element. When at the desire of the promisor, the promisee or any other person has done something or will do something. Now here, one important case law is there. Durga Prasad versus Baldev. Okay, the case is Durga Prasad versus Baldev. Now here, I am explaining the point when at the desire of the promisor. Now, there was a market, and in this market there were several shops. The district collector had requested D, a person, to get the market repaired so that the customers who come to the market have a pleasant shopping experience. Okay. So here there is a market. The district collector requested D to repair the market so that the customers have a pleasant shopping experience. The shopkeepers in that market, they all paid some, promised that they will pay some commission to D if he repairs the market. Now here you see, district collector is there, D, the person is there, the shopkeepers are there. The district collector had requested the person D to repair the market. The shopkeepers have promised to pay D a commission if he repairs the market. D carries out the repairs. After that, D is asking the shopkeepers to pay him the promised commission. The shopkeepers refused to pay the commission. The case went to the court of law. In the court of law, it was held on whose request did you get the market repaired? It was on the request of the district collector. Did the shopkeepers ask you to repair the market? No. On whose desire you have done something? At the desire of the district collector. Why should the shopkeepers pay you? Because they have not desired anything. They have not desired anything, and you have not done something at their instance, at their request, at their proposal. You have not done anything. So therefore, the shopkeepers were not required to make that payment of commission to D. This was the case. So this is case in point which proves that at the desire of the promisor, then at the desire of the promisee, the promisor has done something. Then second, if you look at the definition that we have said, when at the desire of the promisor, the promisee or any other person, which means the consideration may move between these persons, okay, and the act or that something may be done by the promisee or by anybody else. Okay, it may be done by the promisee or anybody else. So when at the desire, so here every stranger to the consideration must can sue on a contract. Say there is a case here. The case is Chinnaya versus Ramaya. Now in this case, there was an old lady. Now this old lady made a deed, okay, made a deed over certain property to her daughter with a condition that the daughter should pay an annuity, which should pay an annuity to the lady's brother. Okay, that is the daughter's uncle. You understood? A lady was there. Now this lady, this case is called Chennaya versus Ramaya. Now this lady, see, she said that she is going to transfer some property to the daughter if the daughter promises to make an annual payment to the lady's brother. The daughter said, okay, I will do it. So the contract was entered into, the property was given to the daughter. Subsequently, the daughter refused to pay the annuity to the uncle, saying that, why should I pay the annuity to the uncle? What has the uncle done to me? What is the consideration that the uncle has given me? Why should I honor the promise? Is what she said. The court of law said that consideration has moved at the desire of the promisor. And the definition says, at the desire of the promisor, the promisee or anybody else. So because the promisee wanted the annuity to be paid to the brother, the contract is a valid contract and the daughter has to pay the annuity to the uncle. Okay. The next, there is something called as stranger to contract. A stranger to contract cannot sue. Stranger to contract means A and B enter into an agreement that B will supply goods to C. Okay, the contract is between A and B. C is a stranger to the contract. Okay, a stranger is a person who is not an immediate party to the contract. So the rule of law says that for any contract to be valid, there should be privity of contract between the promisor and the promisee. There should be privity of contract. Okay. Now here, there are certain exceptions to this rule. The rule is that a stranger to a contract cannot sue, cannot file a case. That is the rule. But there are certain exceptions to this. Exception meaning that where it is by way of an element of trust, or it is a family settlement, or if it is an assignment of contract, or if it is marriage settlement of a minor, then the rule that will not apply, that is stranger to a contract cannot sue. Then the next essential element of a valid contract was capacity of the parties. Okay. Now capacity of the parties, yesterday or in the previous class I had told you that there are three parties who cannot enter into a contract. One is a minor. Okay, a minor cannot enter into a contract. Then second, a person of unsound mind cannot enter into a contract. Then third, a person who has been prohibited by law cannot enter into a valid contract. These are the three classes of persons who cannot enter into contract. Now first we will see what are the legal rules regarding a contract with a minor. Okay, legal rules regarding contract with minor. Now the rule of law says that all agreements with minors are void ab initio. Okay, all agreements with minors are void ab initio is the rule of law. So void ab initio means void from the very beginning. From the very beginning they are void. Now, in case you say that all contracts with minors are void, then how should the minors live? How should the minors sustain themselves? So that is why there are certain exceptions to this rule, that all contracts with minors are void. There are certain exceptions. The first exception is a minor can be a promisee in a contract. That is, contracts can be entered into for the benefit of the minor, because you cannot say that contracts are void. So if you say all contracts with minors are void ab initio means from the beginning, then it will be very difficult for the minors to sustain themselves. That is why relaxation is made in case where the contract is entered into for the benefit of the minor, meaning the minor is the promisee in the contract. In that case, the contract can be valid. Then any agreement with a minor cannot be ratified after he attains the age of majority. Why do you think that contracts with minors are prohibited? Because minors are said to be persons who are less than 18 years of age. So they may not be knowing the consequences of the contracts into which they are entering into. So to protect the minors, the court of law will throw a blanket of security around the minors, saying that minors have to be protected because of their minority. In the same way, persons of unsound mind also will have this inherent incapacity to contract, because their thinking power is not equal to the thinking power of a normal man. So if contracts are entered into by persons of unsound mind, they may enter into a contract that is detrimental to their own interest, that is harmful to their own interest. So therefore it is void. But if a contract is entered into by any minor for necessities, then such a contract will be a valid contract. Okay. Now, here, there is a famous case called Nash versus Inman. Nash versus Inman. Now, in this case, a minor, he went to a garment store and he purchased 11 waistcoats. Okay. He purchased 11 coats from the shopkeeper. Subsequently, he refused to make the payment. The shopkeeper went to the court of law for enforcing the contract. The court of law mentioned that 11 waistcoats are not necessaries. A minor is liable only for necessaries. Because this is not an item of necessary, the minor is not obligated to make the payment, because contracts with minors are void ab initio. Okay, the minor is not obligated to make the payment. But however, services rendered to the minor like education, training for a trade, medical advice, legal advice, etc., in such a cases, the private estate of the minor is liable for the debts. Okay. Then next important element of a contract was, the contract has to be entered into by the free consent of the parties. Yesterday, I was telling you about what is free will. A contract is said to be entered into by the free will, free consent of the parties when it is entered into not due to coercion, undue influence, misrepresentation, fraud, or mistake. When these five things are present in consent, consent means willingness. When these five things are present in the consent of the parties, any one of these five, that is, he has given his consent by coercion. Coercion means force. Second, he has given his consent by undue influence. Undue influence means not physically forcing, but because of your position, you are able to dominate the will of that person. Then undue influence is there. When the consent is obtained by misrepresentation, that you have told him lies, you have not told him the full facts, you have hidden the facts from him, and then you have taken his consent, it is not valid. Then when it is entered into by misrepresentation or fraud, fraud means committing or threatening to commit any act forbidden by the IPC is fraud. So when you enter into a contract by defrauding the other person, by taking the will of the other person, by covering up things detrimental to his interests, then such a consent is not free. Then by mistake, that is, assuming certain state of affairs, you have said yes to the contract. You made a mistake. You actually wanted to say no, but you thought that this is the state of affairs. So that is why you have given your consent. That also is not a valid consent. Okay. So then we will just discuss about this free consent a little bit. I told you that consent is not free when it is induced by coercion. Okay. Coercion means, what is coercion? Is the committing or threatening to commit any act forbidden by the Indian Penal Code is coercion. Now there is a case law here. This is Ranganayakamma versus Alwar Shetty. Ranganayakamma versus Alwar Shetty. Now here, Ranganayakamma was a 13-year-old girl. Okay, she was a 13-year-old girl, and she was married to a person. Okay, usually at that age, marriage is not allowed, but we will not go into that. At 13 years of age, she was married to a person. Now that person died. That person expired. The relatives of that person, they said that they are not going to allow the cremation of the body if Ranganayakamma does not transfer certain properties to them. They said that you have to sign a deed of transfer of properties to us if you want your husband's body to be cremated. This is coercion. Disallowing the cremation of a body is prohibited by the Indian Penal Code. So what the relatives have done? They have done something which is prohibited by the IPC. In order to allow the cremation of her husband's body, Ranganayakamma signed the deed because she wanted the husband's body to be cremated. She did not want it to be left lying there. So she signed the contract. Subsequently, she went to the court of law saying that her consent is not free because it was obtained by coercion. Sorry, it was obtained by coercion, by force. Therefore, the contract is not a valid contract. The court of law held that the consent of the party was obtained by force. Therefore, the consent is not a free consent, and for a contract to be valid, the consent has to be free. Because it is not free, the contract is not a valid contract. Okay. Then second, undue influence. What is undue influence? A contract is said to be entered into by undue influence when one of the parties is in a position to dominate the will of the other party. Okay. One of the party is in a position to dominate the will of the other party. And second, he has used that position to actually dominate the will. Okay. Now, how will this happen? Suppose, for example, I am a doctor, you are a patient. Okay. If as a doctor, I am directing you to do something, even though you are not willing to do it, you may do it because I am in a position to dominate your will. We'll take another example. Suppose you have some, now here also I think there is a case, that is Inchi Noven versus Sheikh Umar. Okay, Inchi Noven versus Sheikh Umar. Now, if you want to go through your study material, whatever I'm telling you is on page number 22. Okay, on page number 22. Okay, are you there? Are you listening to me, students?
Yes, sir.
Okay, thank you.
Yes.
Okay. So here in this case, what happened? There was an old lady. Now this old lady was bedridden and there was a medical attendant. This medical attendant used to take care of all the needs of the lady. Her needs for medicine, all her personal needs, this attendant was taking care. The old lady was impressed by the attendant. So therefore, she transferred a substantial amount of her property on to the name of the medical attendant. Okay, on the name of the medical attendant, it was completely transferred. Subsequently, the old lady died. Okay. The relatives of the old lady, they filed a case against the medical attendant saying that he has obtained the consent of the old lady by undue influence because he was in a position to dominate the will of the old lady. Okay, he was in a position to dominate the will of the old lady and he has used that position to get the assets transferred onto his name, was the contention of the relatives. What do you think the court of law might have said here? Can anybody tell me? You understood what I'm trying to tell you? The case, there was an old lady. This old lady was bedridden. A medical attendant used to take care of all the needs of the old lady. The old lady transferred a substantial portion of her property to this medical attendant. After the death of the old lady, the relatives of the old lady filed a case saying that the medical attendant has used his position to dominate the will of the old lady to get the assets transferred onto his name, to property transferred onto his name. In the court of law, it was decided that the contract smells of undue influence. The contract smells of undue influence. Therefore, the contract was set aside. Okay, the contract was set aside because the person was in a position to dominate the will. Therefore, he has used the position to dominate the will. Okay, this is about the concept of undue influence. Then coming to misrepresentation. What is misrepresentation? Okay. Now, misrepresentation meaning Suppose I want to sell my laptop to you. Okay, I want to sell my laptop to you. I will tell you that this laptop has got certain configuration. I will tell you the configuration. I will tell you the model. I will tell you the year of manufacture. I will tell you how well it is working. Okay. Whatever I'm telling you, they are known as representations. They are known as representations. When this representation is wrong, it is known as misrepresentation. Okay. When the representation is wrong, it is misrepresentation. Now here also, when I am making this representation, I may believe it to be true when I'm making it. I really think that this laptop is of 2020 model. I really think this is 2020 model. When I really think that it is 2020 model, then this misrepresentation is unintentional. But if I know that this laptop is not 2020, it is even older than 2020, but still I tell you that this is 2020 model, then this misrepresentation is intentional. Remember, when I believe the representation to be true, but it turns out to be false, it is called misrepresentation. When I give a representation, knowing fully well that it is wrong, but I tell you, then it is called intentional misrepresentation, which is known as fraud. Okay, I have done a fraud. So contracts which are entered into either by misrepresentation or fraud are not valid contracts. Okay, they are not valid contracts. Then coming to mistake, the last one. What is mistake? Mistake is that it is an erroneous belief in something. Okay, an error. See, I made a mistake. Usually say, I made a mistake. Is it intentional? No. Mistakes are unintentional. And is it fundamental? Mistakes will not be fundamental. They are just minor things. So contracts that are entered into by mistake are also not valid. If this mistake is fundamental to the contract, then they are void. If this mistake is not fundamental, okay, I'll give you an example. Suppose I sell my A, suppose A sells his wild horse to B, telling him that it is a tame horse. It is a Sida Sada horse. A knows that it is a wild horse. Okay. B does not know it. Looking at the horse, B feels that the horse is a timid, tame, and nice horse, good horse. So he has accepted the representation of A. Now, if A knows that the horse is wild, then it is fraud. If A doesn't know that the horse is wild, it is a mistake. Mistake may be unilateral or again bilateral. Unilateral means mistake on one side, but not on the other side. Bilateral mistakes are both the parties are mistaken about the subject matter of the contract. It is known as bilateral mistake. Okay. So we have seen what are the essential elements of a valid contract. Okay. Then we will talk about, we will go to the next unit, performance and discharge of contract. Okay. Performance and discharge of contract. what is the meaning of performance and what is the meaning of discharge of contract and what are the various ways in which a contract is discharged. Okay, see, performance meaning when every contract will have certain duties and responsibilities. Suppose my contract says that I will supply goods to you. I have supplied the goods. Performance is over. What is your duty? You have to pay the price. You have paid the price. Performance is over. So when performance is over, it is called discharge. Discharge of performance. And what is performance? Doing that thing that is accepted to be done is called performance of the contract. A has promised to supply 100 watches to B. When A has supplied 100 watches to B, contract is performed. When B has paid the price of 100 watches to A, the contract is performed. A contract, when performed, gets discharged. Okay, this is the meaning of performance and discharge of contract. Then who can demand performance and who can perform a contract? Okay, who can demand a performance? The person to whom you have promised that you will perform your obligation, that person can demand the performance. Okay, then who can perform the contract? The contract can be performed by the promiser himself. Okay, that is A himself, or can be performed by the agent of A, or can be performed by the legal representative of A. So it can be performed either by himself or by anybody else acting for the original person. Okay, now here I will just tell you one line about agent. Who is an agent and what is agency? When a person wants to do anything, except certain things, of course, when a person wants to do anything, he can do that thing either by himself or he can ask somebody else to do it. Okay, he may ask somebody else to do it. When he is asking somebody else to do it, that somebody is known as agent, and the person who is asking him to do it is known as principal. Is known as the principal. The agent and principal relationship exists between these two persons, except of course things which require personal involvement. Suppose, for example, I cannot ask B to marry C on behalf of me. No, I cannot. If I am a doctor, I cannot ask my nurse to treat the patient on behalf of me. No, I cannot. If I am a singer and I sing beautifully, I cannot ask somebody to sing on behalf of me. If I am a lawyer and I am practicing law, I cannot ask somebody else to practice on behalf of me. Now here, what are the examples that I have quoted? These examples are such that my personal involvement is required. If I have to treat a patient, then I have to do it myself as a doctor. I cannot ask my nurse or my compounder to do it. If I am a singer, it is my voice that is being asked. I cannot ask X and Y to sing on my behalf. If I am a lawyer, I cannot ask somebody else to argue the case on my behalf. Okay. So where a person has performed a contract, either he himself can perform or he may ask somebody else to perform. Okay. Then see, there are certain promises which are mutual and independent. Suppose I give you something, you give me something in return. That is a mutual agreement, a mutual contract. Then coming to the ways of discharge of contract. How is a contract discharged? A contract is discharged by any one of the following ways. It may be discharged by novation or alteration, remission, accord, or rescission. Okay. First one is novation. What is the meaning of novation? When a new contract is entered into in place of an old contract, novation is said to have taken place. Novation is nothing but substituting the new contract with an old contract. Then alteration. Alteration means when in the contract certain terms and conditions are sought to be changed. When there are changes in the terms and conditions of the contract, then the contract is said to be discharged. Okay. Then remission. Remission means giving up. When a person promises to give up something on the name of another, on behalf of another, it is known as remission. Then coming to award or satisfaction. So here, suppose for example, I have made some changes to the terms of contract and you have accorded your permission. So based on your accord, I have performed my part of the duty. Okay. So here performance also can be through accord. It can be also through rescission. Rescission means canceling the terms of contract and in place of that adding a new term of reference. Suppose for example, in the previous case I told you novation. What is novation? Substituting the entire contract with another contract is novation. What is remission? Within the same contract, certain terms are changed. When certain terms only are changed, it is known as rescission. Okay. So these are the different ways in which a contract is generally discharged. But not always a contract is discharged this way. Sometimes one party, okay, one party may die. Okay. If one of the parties to the contract dies by death, the contract is discharged by death. Then when there is a change of law, when there is a change of law, the contract may be discharged. Then the contract may be discharged either by the destruction of the subject matter. Suppose, for example, I have an auditorium and I say that I want to give this auditorium on rent to a film direction company. Okay. Suppose subsequently my auditorium is burnt down completely by an accident, fire accident. Then can I undertake my promise? I cannot, because the subject matter is the hall where the performance would be carried out. The hall itself is not there. How can I carry out the contract? So the contract is said to be discharged in this case also. Then discharge by outbreak of law, discharge by termination of law, discharge by lapse of time, and discharge by intermination of mutual interest, discharge by breach of contract. Okay. So these are the various ways in which a contract is discharged. Suppose a contract is not discharged. Example, I have delivered the goods, you have not paid the price, or you have paid me the price already, but I have not delivered the goods. So when I pay the price, my part of obligation is over. When you do not do your part of obligation, then the contract is said to be breached. Breach means breaking of the contract. Okay, when one of the parties does not perform his part of obligation. Okay, when he does not perform part of his obligation, then the contract is said to be discharged. Okay, then when a contract is discharged, when a contract is breached, when there is a break in the contract, what are the various remedies available for breach of contract? Okay, if there's a break in contract, there should be remedies. The first remedy is rescission of the contract. Okay, rescission of the contract means that where they see, when any contract is broken, there is one, the aggrieved party. Okay, the aggrieved party and the plaintiff and the respondent. The plaintiff is a person who thinks that he is plain and innocent. He is the one who will go to the court of law. Then who is the opposite person? The opposite person is known as the respondent. Okay. The opposite person is the person who has made the breach of contract. So where the person who has made the breach of contract, in response to his breach, the other party has decided to let him go. Okay, has decided to not to allow him to perform the contract, then the remedy is rescission of contract, which is nothing but cancellation of contract. Then when there is a breach in the contract, you can file a suit for damages. Suit for damages. Okay, suit means case in the court of law for damages. Now damages usually are of different types. Okay, damages may be ordinary damages. Whatever is the loss that has been incurred by me, you pay me that loss. This is an ordinary damage. Then damage may be special damages. Okay, special damages are damages which are not natural, not a natural fallout of the breach of contract. Suppose, for example, now you said that you are going to supply the car to a customer on Monday. The customer wanted to go to his job interview in the car on Tuesday. You have not delivered the car to him on Monday. Then what you can do? Sorry, the seller has not delivered the car on that specified date. So what can the buyer do? The buyer can claim ordinary damages, that is damages that he has incurred because of the non-performance, or he can claim special damages, that is because you could not give the car to me, I could not go to the job interview. Because I couldn't go to the job interview, I could not get the job. Because I did not get the job, I have lost a salary of 1 lakh per month. Now you pay me that 1 lakh. That is special damage. Okay. Ordinary damage is damage that arises out of the contract. The special damages are beyond the contract. The next, exemplary or vindictive damages. Exemplary or vindictive damages are those damages that are paid by the party who is in default to the party who is not in default at a very exorbitant rate. They are known as exemplary. At a very exorbitant rate, they will pay the damages to the party upon breach of contract. When this happens, it is called as vindictive or exemplary damages. Then nominal damages. What are nominal damages? Nominal damages are those damages which are paid just for the sake of paying. The parties are not really seriously interested in the contract. So even if one of the parties doesn't want to, has made a breach, the other party may just for the name of say, for the sake of name, may claim certain damages from the other party for record purposes in the future. Such damages are called as the nominal damages. Then, a party who has suffered a breach of contract may go to the court of law asking for that person to perform the contract. He can file a case saying that he has to perform. I don't want damages. I don't want any exemplary or normal damages. I want that person to perform his obligation. In that case, the court will give a direction to that person to perform his part of the obligation. Okay. Then the next one is quantum suit upon quantum merit. Suit upon quantum merit. What is quantum merit? Quantum merit meaning as much as earned. As much as earned. So in this suit for quantum meritum, the aggrieved party, that is the party not in default, will ask the court of law to direct the other party at least to pay him off the loss that he has incurred on account of non-performance. On account of non-performance of the contract, whatever loss the SSC has incurred, he will ask the other party just to make good the loss. In case it is accepted, then it is called as suit for quantum merit. Okay. So with this, we have completed the first block. Then the second block, as I told you, we will talk about special contracts, contracts of indemnity and guarantee, contracts of bailment and pledge, the law of contract of bailment. Okay. Now, anybody has got any doubts here?
No, sir.
No? So shall we
No,
leave?
sir.
Okay then. So thank you very much for your patient hearing. Tomorrow again we'll have the class at 1:30, and in tomorrow's class I will finish off block 2, that is indemnity and guarantee, bailment and pledge. So for now, thank you very much for your patience. Have a nice day.
Thank you, sir.
Thank you.
Thank you, sir.